Okay, so I'm so excited because we talked a little bit about the Supreme Court rulings, but now we're going to really talk about the Supreme Court rulings. Let's welcome in David Katz, the former federal prosecutor, now defense attorney. Hi.
Great to be with you today.
Thank you for braving traffic to get here to talk about it because we've got some pretty important rulings that came down. First of all, let's talk about the student loan debt forgiveness, which I kind of understand. And I was talking about Justice John Roberts, who had quoted Nancy Pelosi in his ruling today, saying that she had talked about that the president didn't have the right to do this, that it was a legislative power. And that's later on she came around and said she supported the president, but back when he was running for office, she said the president can't do that anyway. So what are your thoughts?
Well, Kim, those things are very selective because obviously people are trying to determine whether something is legal. It's a difficult question. I think in fairness, Pelosi was trying to say, there are some issues here. Why have any issues? If you want to have the student debt relief, bring it into Congress and we'll try to build a consensus to back it. Now, of course, the problem is that there is a consensus, a Democratic consensus to back it. There's a Republican opposition to it, that it's some giveaway, and they think that somehow it's going to appeal to working class voters, that this is a bailout for rich kids, which of course it's not mainly a bailout for rich kids. It's very hardworking people who got through school, which is ridiculously high, by taking out these loans. And then a lot of times they went into fields or they went into job markets where they really couldn't repay the loans. And so there's been a lot of politicking over the issue. And so I think Roberts was like, see, gotcha. But, it's so funny because does Roberts want to do what Pelosi thinks is legal and not legal on Dobbs and overturning Roe v. Wade? Does he want to do what Pelosi thinks is legal and not legal and get rid of Citizens United? And of course, Roberts was really posturing on this because the law says that the president does have the power under this Pandemic Relief Act to modify student loans. So the argument is that he could modify them and suspend them. You could not pay for years, which is what's happened. People have basically not paid for years on these loans. Probably over 90% of the people, Kim, are not paying on these loans. They have loan suspensions. Biden ran on not just a suspension, but of some relief. So it would be up to $10,000 or $20,000. And I just have to say one note here. When you look at the relief that was given to businesses during all of these things, going all the way back to TARP, but now, of course, the one that everyone's thinking about, the PPP, all of these relief acts, billions of dollars going to companies. The argument, if you'd opened up an auto body shop instead of going to college, if you'd gotten a loan to start your auto body shop instead of to get your college education. Well, the reality for this appeal to the working class to try to get them mad at people who went to school when they didn't have the opportunity to go to school or they didn't want to go to school, and I have a lot of sympathy for those folks. They did relieve a lot of their burdens. They did relieve a lot of their financial burdens. And of course, I think just to sort of round out my thoughts on this as a preliminary matter, this will become a campaign issue because it's been perceived as very much having Republican opposition. There are millions and millions of people who have these student loans. As I said before, it's just giving them $10,000 of relief from having to pay back, at most $20,000 for some people. And yes, they could find somebody who's a poster boy or poster girl for someone who probably should be paying back the loan. But there are millions and millions of people who just can't. They don't make enough money. I think 60% of people were not paying back these loans, were not servicing them even before the pandemic. So it's a very, I hate to be cynical, but it's a very popular issue for the Democrats. They're giving a small amount of relief to millions and millions of people who need it. And the Republicans are standing athwart of this. They're stopping this when they've given away billions and billions of dollars to their friends, their cronies, the Republicans, big contributors, big business, small business, and they won't give $10,000 or $20,000 to millions and millions of people. You could start doing the campaign ads in 2024 for the Democratic candidates.
Does it say something about what the president's powers are? Is this just applying to this ruling only, or is it a broader discussion of what the president can and can't do?
Well, there's something called the major case doctrine, and in the dissent, Kagan lampooned this major case doctrine and said it was totally made up. And I agree with Justice Kagan and the two who joined her that it's totally made up. It's just out of whole cloth because the Republicans see a way to not approve what they call the administrative state, the regulatory state. And I don't want to get too inside baseball, but the idea is this. Obviously, the courts have to interpret statutes. If a statute says you can modify, does a modification mean completely stop? And the Republicans and the Supreme Court justices, the six of them, think that they've got them. Gotcha, right? Gotcha. Modify isn't stop. Chief Justice Roberts, who wrote the decision, said, well, this was modified in the way that the French nobility was modified by the French Revolution. They were exterminated. So obviously getting totally rid of a debt, even if it's 10 or 20,000, is not a modification. So they say it statutorily doesn't follow. And if Roberts had stopped there, that would be one thing. But then he invoked this major case doctrine, which is that something of this importance, it has to be crystal clear by Congress. And so the word modify does not crystal clear mean, extinguish the debt, completely knock out the debt. And so that's what Kagan said. Kagan said, maybe it's okay. I disagree with you. I think that modification in this sense, in the Pandemic Relief Act, this was part of the pandemic relief. There are still a lot of problems with the pandemic. There are still a lot of problems with the economy. I think it's a fair interpretation. But even if we disagree on that, don't invoke this major case doctrine, which says you have to micro describe in the statute. There's no rule that you have to micro describe in the statute what you want to do. You just have to describe it. So what people are worried about is that in some statute that says we're going to deal with the environment, we're going to deal with environmental harms, that when they say, okay, that includes regulating power plants, we didn't specifically say power plants, did you? And so just doing something about air pollution and environmental problems, it doesn't micro describe that includes power plants. So you can't regulate the power plants. And while I'm lampooning that, that's actually what people are really worried about. And that's what Gorsuch and that gang are always invoking, this major case doctrine to basically make it a higher level to approve regulation, especially of the fossil fuel industry.
Let's switch over to the ruling about the LGBTQ discrimination. The
Can I
court
just say
ruling.
one last thing about this?
Oh, yeah, please.
Biden is going to try very hard to find some way to get relief. He's under a lot of pressure from student groups. He's under a lot of pressure from these millions of people who are just got very bad news today that they're going to trying to resume the collections. They're going to get those dunning letters. They're going to get hassles. They're going to get, I guess, if the government can do it, they're going to put liens, levies, you name it, and make life difficult for millions and millions of people who really cannot repay those loans, but they're going to give them a huge hassle. And those people are going to be, I think, galvanized first to demand new legislation or new action. And then I think they're also going to be inspired to vote Democratic in 2024. Let's go ahead to 303.
Yes, this is the 6-3 ruling that said the Colorado web designer, her name is Lori Smith, does have the right under the First Amendment to refuse to endorse messages she disagrees with. Doesn't have to put up this website or work on this website because she disagrees with LGBTQ issues based on her religion. So it's okay then to use religion to discriminate? Is that what the court ruled?
In this instance, yes, the court ruled that you can discriminate on this basis, from which you have to conclude that gay marriage and rights to associate in that sense are secondary rights. Because if this had been two blacks getting married, if this had been a Hispanic getting married to a non-Hispanic, if this had been a Catholic getting married to a Jew, there couldn't have been this discrimination. And so those are first-class rights. And so gay people are rightly indignant that, okay, so our rights are second class. I mean, the irony is that gays could not discriminate against a Catholic customer or a Catholic would-be customer. Think about that. But the Catholics or the evangelical Christians can discriminate against gay people.
Well, how is that fair?
Well, it's not fair. It's not fair. And what that means is that these are second-class rights, that what would not be permissible if you discriminated on the basis of race, religion, ethnic status, you can do on the basis of the fact that it's a gay couple if two things are present. If you supposedly have a religious belief in that,
Yeah.
that you believe that it's wrong, it's under the Bible or under your religion, that gay people get married, you have that religious conviction. So if religion is your reason for not doing it, then that's impermissible. Uh, and also, if you have to do something that's sort of artistic. Remember, we had the guy who made the cake,
Yeah.
that was like 4 or 5 years ago, and that case got sent back on a procedural technicality that the Civil Rights Commission in Colorado hadn't fairly heard his claim of a religious exemption from having to make the cake. And people said, wow, make a cake. How creative is that? The idea is that you shouldn't be forced to speak or write or act on behalf of somebody in a creative way when you don't believe in that. They're forcing you to speak, they're forcing you to act, Kim, in a certain way. That's the argument. And the question is, does designing a website go far enough? And the Supreme Court says 6-3 that yes, designing a website is far enough. Now, painting a fence, when someone calls and says, hey, I want you to paint my fence, and you say, I don't believe in gay people living together. I see that you're two gay people living together. I won't even paint your fence. I know you want it repainted white. That person probably has to paint the fence white, right? To do a mural, right? On your fence that shows two gay people holding hands. That is probably covered by this ruling, and the person could say no. But this whole thing is, people are very suspicious of this. They think this is very manufactured. However you feel about the issue, there is this idea of standing. There's this idea that, the courts just don't issue advisory opinions, or because you want an opinion, you should get an opinion, right? That you really have to have a case and controversy. That's what the Constitution says. And so it has to be standing because it's a real case. It's not just a made up case. This one looks very much like a made up case. So it's come out now that the person who supposedly wants the website done didn't want the website done. Somehow this was either phonied up, or it was a test case or a reverse test case where this religious organization wanted this ruling. And so they sent
Oh.
out this thing that looked like it was a request, because what it actually said was, we're having a wedding, we're two gay people, we'd like you to do the placemats, we'd like you to send out the invitations and design. We might even go as far as wanting to have a website celebrating our wedding. Website. So it was only conjectural that there was ever going to be a website. It was not very clear that this person even wanted the website. Now it turns out that this person has come out and said, not come out in that sense, but
Yeah.
has been interviewed. Somebody finally found this person, interviewed them, and said, wow, this is really interesting. I didn't want anything. I did not send this. I swear under penalty of perjury, I did not send this thing. Now, their argument is that they're entitled to get declaratory relief because this could happen. And once you say, I'll do websites for anybody or place cards or whatever for any wedding except a gay wedding, if you put that as your ad, the Colorado Civil Rights Commission would come after you. So the argument is that you had a right to a declaratory judgment. You had a right not to be intimidated. You were trying to exercise your religious rights to not do something that you claim your religion forbade, and yet you were about to get pounced on by the Civil Rights Commission. So the Supreme Court said that there was standing for this thing. But the other case was also questionable, by the way, because that was one that also they said the student debt forgiveness shouldn't have been reached, because it was 6 Republican states that didn't like it. And, again, there should be more standing. There's always going to be some state that doesn't like just about any federal policy. New York or California will challenge just about any policy that they don't like that's passed by the Republicans in Congress. And Texas or, Alabama will challenge every one that the Democrats like. That's not standing. In both cases, the Supreme Court says there was standing. They reached both of them. And to some extent, it's great. We do news, and this is breaking news. This was the most predictable news.
Yeah.
That's broken in a while. They knew Gorsuch was going to write this opinion. They knew it was going to be 6-3 from the arguments and from the way the Supreme Court assigns cases. They knew this other one was going to come out this way too. They've already started in Congress. Remember about now Biden cannot resume the student debt under certain circumstances. That was in that package that they did so that we would pay our debt. Remember that crisis 2 weeks ago?
I'm flabbergasted that there's no recourse if there is not really a plaintiff, if there's not really a web designer that feels wronged, that then this ruling would be able to stand, and that this is not a real case.
Well, there are these advocacy groups. They exist both on the left as on the right They exist for gay rights groups, right?
Sure.
Just like they exist for these religious organizations. This was a particularly well organized one that brought this suit. I believe they were the same ones who brought the cake maker suit 4 or 5 years ago that got thrown out. And they obviously structured this to happen. And as I said, there is an argument that there was standing and that this was a real case in controversy, because had this web designer taken this position, they would have gone after her under the anti-discrimination laws that she was discriminating against the LGBT community. So
Yeah.
there was an argument for that. The other thing is that they had lost in every court. So to some extent, they had a good argument against this, that it was discrimination against a protected group and it was impermissible. So they won in the district court. They won in the conservative court of appeals. The only place that that gay rights lost was when it finally went to the Supreme Court 6-3. So it probably didn't come up, Kim, as much of an issue as maybe people would have liked in retrospect. But once the Supreme Court, there's certainly no recourse. Once the Supreme Court says they're standing, there is a case in controversy 6-3. Like it or lump it, we're the U.S. Supreme Court. We're the supermajority that's in there because of Trump, and that's because Kavanaugh, Barrett, Gorsuch are such predictable votes on these things. And then you add in Alito and Thomas, and even Chief Justice Roberts can't stop these results. They're going to be either 6-3 or 5-4. But
Yep.
gay rights and a woman's right to choose, gun rights, those things are going to lose until we have 11 or 13 members of the Supreme Court, which of course is a bill that was just introduced recently that could be done by legislation, but is of course not going to go anywhere as long as there's still a Republican House.
I was looking at, reading a little more in depth about yesterday's Supreme Court ruling, and how Justice Ketanji Brown Jackson, is it?
Mm-hmm.
And Clarence Thomas were kind of going back and forth with, what it means to be basically Black in America, and how they were kind of really sniping at each other in a way. And I thought that was pretty interesting how they could have such different experiences.
Well, I consider what Thomas writes completely phony, because he is a huge beneficiary of affirmative action.
Right.
If he wants to prove to the nation, besides the fact that he's fair on these cases after he takes these junkets and doesn't declare them, and everything else that's wrong with him, his wife who's like sending insurrectionist stuff, and then he doesn't even recuse himself on that case and votes in a way it doesn't come out. He hits me as someone who's completely incompetent, should never have been on the Supreme Court, is really a disgrace to that institution. But if he'd like to prove, what did they used to say all the time about all of these Democrats that they didn't like? Let's see the grades. Let's see on what basis he got into Yale Law School. I think the whole nation would love to see it. And then we could say whether he's a complete hypocrite, having gotten these advantages in life by having an add-on, right? By affirmative action, and now being this big opponent of affirmative action. So what's his argument? I got here by that, and I don't believe in it. So I just totally used something I don't believe in, or it was good for me because I went up that ladder, but I don't want to see anybody else who's struggling, who's worked hard, go up the same ladder that I went up. I mean, nobody understands his argument except that he is a complete hypocrite.
His argument was that he admits he got into Yale based on these policies, but that when he graduated, because of these policies, he was still discriminated against. And so he stuck a 15-cent sticker from a piece of fruit onto his law degree saying it was worth nothing. That he felt that if he was able to get into law school based only on his, transcripts and everything that he had done, that somehow that would be worth more than how he got in. So that
no
was
one
his.
knows what he's talking about. The photograph behind me is Judge John Garrett Penn. Can you still hear me? Because you went to. Okay. Is Judge John Garrett Penn. He was a very distinguished judge in Washington, D.C. He was the chief judge for a while. I had the huge honor to be selected as his law clerk and to work for him as a law clerk. Let's see what happened to him. He's not that different from the era of Justice Thomas. Okay. People said to him, this is great that you're getting a law degree because it'll really help you. It'll give you a big leg up to get a job at the post office. Yes, that's the world of that era. But when he got into school, totally on his merits, he got into every school, totally on his merits. And then you're right. Thomas is right in one sense. It was hard to get a job. So what did he do? He got the job that he could get in law. He went into the JAG Corps. Then he won case after case in the JAG Corps under Eisenhower. And by the time he left the JAG Corps, it was 61 or 62. Bobby Kennedy hired him to work in the Justice Department. He got promoted because he was so terrific. And the area that he got was the South. This is before the Civil Rights Act, Kim. So he went to the South with a federal badge as a federal supervisor of tax collections for the Department of Justice Tax Division on a segregated railway car and had to drink from colored water fountains. And he appeared in federal judge. He told me the story of a federal judge who turned his chair away from him so he wouldn't look at him at all during any of his argument. Guess what? He won those cases. He did great. Okay. That's the experience that people should emulate. So if you look at that, if you look at Ketanji, KBJ's history, if you look at her history too, where is the support for what he's talking about? What we should never have affirmative action because my judge managed to make it without it. Why? My judge was for affirmative action in appropriate cases because these people who say the best way to stop discriminating on the basis of race is to stop discriminating on the basis of race. That's what Chief Justice Roberts always says. They're blind to history. They want colorblind, but they're the blind ones. They're blind to the history that the country needs some remedies. And so for Thomas to always vote against remedies, for not only for African Americans, but for Hispanic Americans who have also been disadvantaged in some ways. By the way, I want to make one comment about individualized consideration for colleges, universities, and job opportunities. You know, many Hispanics are completely bilingual. They know 2 languages. Think about that when you start to do the individualized consideration. That should give them a big break. Now, some of the Asian Americans are also bilingual. I'm bilingual myself, so you can say this is special pleading. But at the same time, I do believe that it is an intellectual advantage if I were doing the individualized consideration that someone is bilingual. So I don't see that this is going to hurt Hispanic Americans. It may help some Asian Americans, but it may disadvantage some other Asian Americans who are monolingual. But as in terms of African Americans applying, not only to some of them know other languages, but at the same time, they have had this experience that is different, okay, in this country still and based on history. And I think that's something that the decision yesterday really kind of missed. And I think that the individualized consideration, Kim, can end up being a very good thing. So I think the people were a little overwrought who acted like, oh my God, this is terrible. It wasn't good. But I think that there will be ways that institutions like the ones that got sued, Harvard and the University of North Carolina, will still have diversity. And yet these quotas or things that are like quotas are indeed unpopular. They're popular with some percent of some segment of the population, but not enough to have won 2 different ballot initiatives in California. Both times affirmative action lost. It even lost among some African Americans and some Hispanic Americans because they thought it stigmatized them. And so I think that those are my thoughts on yesterday's decision.
Well, thank you. And thank you for rushing in to talk to us about this morning's rulings and circling back to yesterday and putting everything in perspective for us. And I hope we get to see you again next week.
I'll see you next Thursday. And that's it for this term of the U.S. Supreme Court.
Okay.
You know, it's always brutally hot in the summer. And they got in the habit of not sitting in July and August, and they don't. They also don't sit in September. First Monday in October, that's when they're back in session. During the summer, they handle all of these matters like people who want to have their case reviewed by the Supreme Court. There are hundreds and hundreds of them who are almost all rejected, and they take about 80 or 90 cases only for argument during the term.
Okay, well, we'll be watching exactly what they will consider and what's being presented and try to figure out what the next big ruling coming down may be.
Great. See you next Thursday.
Thanks, David Katz. Bye. How awesome for him to be with us for a second day in a row to talk about Supreme Court rulings, important rulings coming down today. But because of that,
Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.